We have lots to talk about, but I want to get the panel involved in the discussion. So I'm going to turn first to Chuck Senator.
Well, tough act to follow. I've spent a long period of time in my life between being a prosecutor or regulator and running two large global compliance programs. And I think in many respects, Judge Rakoff has set up sort of the thought experiment that I wanted to put in front of you very nicely, because and the thought experiment involves the importance of personal accountability, as well as the difficulty to impose compliance from the outside. Almost exactly the words that Judge Rakoff mentioned. It's really more of a values thing. So what I've been thinking about, and again, this is imperfect, it's more of a thought experiment. I'm assuming there'll be lots of views on this. But because of my experience, I've seen that really values drive, this is obvious, I guess, great values drive an organization. I'm privileged to work in one at Fidelity, and I've seen sort of countless examples of times where things happened or issues occurred, and the lion's share of my job was calming people down, as opposed to getting them to understand that there was an issue. So when I think about also what happened in the wake of the financial crisis, we talked about just the tsunami of rules that came out during Dodd-Frank and the whole notion of rules. I began to think as whether, to what extent the reflexive tendency of government, of Congress, of regulators to sort of address a problem with yet another new rule, over time, whether the proliferation of rules really adds to great compliance outcomes. And I am skeptical that they do. So, no doubt rules are valuable. I mean, without them, we'd have crashes at intersections. You need to understand, that you can't run a red light. They create order. They end up taking advantage of the past experiences in terms of where bad outcomes were, and they're good and important to guide us. But they also have their limitations in terms of governing behavior. They're backward looking. They address the problem that came up in the past. In many respects, one could argue that they are fighting yesterday's war. The rule book just grows. Maybe with this administration, in terms of the 2-for-1 thing that they have, in terms of what the president's thinking about, there might be some retraction, but it's like ratchets, you can ratchet up, but won't ratchet back. Rules spawn bureaucracy, not just in terms of the regulators, but in terms of compliance efforts. I mean, at the end of the day, when you have certain requirements, you might find yourselves doing something that might not add a lot of value, but it really are meant to sort of deal with what a rule requires as opposed to dealing with a possible problem. Rules don't evolve. They can become anachronistic. At least and there was a piece that I think Professor Beitlin talked about in terms of circulating some ideas regarding some rethinking about whether FinCEN should be looking at doing more work in terms of dealing with anti-money laundering. There's a view in this study that actually SARs are less than valuable, and yet we have thousands of hours, thousands of people across the industry dealing with SARs. They can't cover everything by definition. And even though we continue to enact them, we will never get to the place where they could cover everything. At some point, we face the prospect of diminishing returns. So when you think about that, then you sort of layer on human nature. Behavioral ethics teaches us a great deal. Frankly, as research shows and as articles along the lines of those written by Don Langervert suggest, left to their own devices, human beings have this tendency to cheat, have this tendency to sort of go around the rules. They don't view themselves as unethical. They won't cheat beyond more than what they think of themselves as being reasonable. But good people will cheat more than they should, but not as much as they could. And this is really a question in terms of the research, is that whether that impacts their sense of self. And concepts like bounded ethicality suggest that many people just lapse and don't even see as they begin the kind of the slippery slope towards actions that could circumvent rules. So we can see that then, in addition to the rules not being able to sort of cover everything, we can see that humans may in fact be wired in some fashion to find ways around rules. While rules can create a standard, they can't legislate behavior. And a lot of that, the sort of the downside around the rules is what happens to the conversations within a firm. And I've had this over my career in compliance. I mean, I'll end up getting questions like, well, what does the rule say? Does the rule, if I do this, will I violate the rule? So the question all of a sudden turns into you're having a conversation about the rule as to whether something is within the rule or without the rule, as opposed to whether something is right. Boiled down, it's more of a question in terms of what can I do versus what should I do? And how this conversation is framed matters. Again, research in terms of concepts in behavioral ethics, like ethical fading, we learn that language matters. Think of, and I don't mean to be very stark or graphic, but collateral damage versus dead bodies. When you have the conversation changes depending on what the language is. People are less likely to cheat, according to experiments in a room, if you actually have the 10 Commandments there versus not being there. People behave differently if behaviors are framed in values versus rules, in my view. And so, although this is probably not a really valid, statistically significant case study, but look at two different rule sets, the broker-dealer rule set versus the investment advisor rule set. If you look at the broker-dealer rule set, it's a tome. You could really, it's inches thick. They're very, very sort of rifle shot, rules-based approaches that determine whether or not you're dealing with issues in the broker-dealer world. The IA rule set is a little bit different. It's grounded in fiduciary duty. And a very well-known Supreme Court case cites a value in terms of making sure you're acting either consciously or unconsciously in the best interest of the client. So, I mean, I don't have data, but when you think about the size of the rule books, can we say that we see materially less violations in the broker-dealer space, the rule-intensive space, versus the much more principle-based investment advisory space? I don't know, but I suspect the answer is no. So anyway, so what does that mean? I mean, in the end of the day, the judge mentioned personal accountability and that you can't impose compliance from the outside. So we know firms can have cultures and values, and here's my thought experiment. Can that apply in industries, particularly regulated industries, let's say like the broker-dealer industry? Because institutions and groups have cultures, very much along the lines of a firm having a culture, along the lines that we were just talking about a few minutes ago. Think of the CFA. Think of, with the apologies to what might be sort of diminishment of courage in the bar, think of the bar. There are standards that govern us as lawyers. They're akin to the values, I would analogize them to like a guild, where sort of like the nuances, the things between the rules, the importance of what's just and what's equitable and how you do the right thing for whatever your trade is sort of learned at the feet of masters. In many respects, an ethical framework can sort of grow in where there's a shared set of values, whether it's in a firm or an industry. There's an ethical framework there, and if it's working well, it's a value system that could end up having different outcomes. So here's the thought experiment, and it sort of ended up thinking about this during a period of time where actually a number of us on this panel actually served at the same time at the FINRA National Adjudicatory Council. For those of you who don't know this, for purposes of hearing appeals from broker and firm disciplinary actions, the National Adjudicatory Council is sort of like the FINRA Supreme Court, after which someone obviously has, an aggrieved party has a right to an appeal to the SEC. But I went back and thought about the deep changes in the NASD back in the mid-90s in the wake of a horrible set of facts where there was conflicts of interest between the interests of the NASDAQ market and where there was sort of possibly infecting the ability of the marketplace to really kind of move off of eighth quotes. And so there was, horrible evidence that there was, market makers actually involved in that instance that required so it required action. And what happened was that the SEC did a 21A report. For those of you who don't know that, they have the power to short of enforcement action to make a report that would sort of talk about the problems that they found. And what happened here is that they did a couple of things. They sort of decoupled the NASDAQ market from the NESD in general. But what they also did is sort of take away some of what I call the true self-regulatory elements, where the industry itself will be involved in policing the people in the industry. So back in those days, cases against brokers had to sort of go through a business conduct committee in a region, where principles, not just of the rules, but also in terms of just and equitable principles of trade, were actually discussed and were actually sort of used as sort of gating factors to determine whether someone should be prosecuted under the NESD rules. And there was some sense that there were too many events of conflict. There was this sense of conflict. There was a sense of maybe the fox guarding the hen house. But experience at the NAC really sort of made me think a little bit differently, and this is what really struck me. Whenever there was debate around whether a particular broker had violated a rule and whether action should be taken, the most insistent, the most harsh, the most judgmental in terms of the fires of hell being brought down on this broker that brought disrespect to the industry came from the industry members, the very same people from the same business that would have been able to take those values and sort of instill them and use them as the basis for deciding what people ought to be done, whether they ought to even be in the industry. So what struck me is maybe we might have gone a bit too far. I think that, so my thought experiment would be, sure, we have people that are flawed. God knows we will have, God forbid, we should never have another sort of financial crisis type of issue. Even the issue that sort of caused the 21A report was horrible. But going down the road by sort of imposing externally a rule set by a regulator, which is essentially, frankly, almost like the junior SEC, as opposed to having the industry itself police, where people are held accountable, where if you violate the law, you not only should be prosecuted or have actions brought against you, but the point is that what may have been lost was that value set, that notion of imposing compliance from the outside. There are probably lots of reasons why this might be a bad idea, but my experience from being within firms and thinking about the importance of values and seeing how those values played out just in some of those NAC hearings made me think that, well, is there a different way of thinking about regulation, particularly in settings like now, FINRA? So let me pause there and see if I can take some incoming from my fellow panelists in terms of whether there's any reaction.
Any thoughts from our other panelists on this?
Well, Chuck, I would just say, hold that thought. I agree with you, and part of what I'm going to talk about is sort of taking your observation and talking about some things maybe we could consider doing to build upon it.
And I guess my reaction is that might be a lovely way to deal with blatant fraud. I don't have a lot of confidence that an industry jury of, say, Angelo Mozillo's peers would have done any better with him than the Justice Department or I think when you look to more complex, nuanced behavior, the notion that the industry can be trusted to self-regulate I find that
Let me just back up a
challenging.
second. I'm not suggesting like we should have an SRO for the mafia. So it isn't as if, that value system is probably not a good one.
And it's not the mafia.
Yeah, but I'm being a little bit flip, obviously. But when you think about the regulatory, I'm using a regulatory example in terms of imposing standards. Clearly, there's a whole level of sort of professional. There's a professional element along the lines of the CFA, along the lines of the bar here. And I admit freely that it may not translate, into something like having the mortgage broker business sort of be subject to an SRO. But the point is that I'm just sort of looking at ways to sort of think about things differently, and maybe the thought experiment really was mostly applicable to something like a FINRA, where people can be disciplined for failing to have honored just and equitable principles of trade. My query there is, how can a regulator that's not in the industry sort of understand that, as well as someone who actually is living those standards and applying them?
So can I just riff right off that for a second? Chuck used as his extreme example of something he's not proposing, having an SRO for the mortgage broker industry. One of the panelists, who will remain nameless, has proposed just such a thing in a paper, and it relates to what Judge Rakoff said. So the problem with the mortgage broker industry, and none of the mortgage brokers that committed fraud, in my view, have gone to jail, or not enough of them have gone to jail. And part of the reason is that it's very hard for the government to show fraud. If you go to a client and you make full disclosure to them, you can put them in a product that is completely unsuitable for them, and the government will not be able to prove fraud. Fraud's a very hard standard to make out. So lots of mortgage brokers put people who were vulnerable. If you were African American or Hispanic in Chicago, for the similarly situated person with a credit score, you were 5 times more likely to be put into a subprime loan. None of those people have gone to jail, because for the government, it's very hard to prove and put people in jail or go after them for fraud. Brokers, and Donna and Chuck and I all saw this when we were FINRA, you put someone in an unsuitable product, and unsuitable there is, it's not right for them. Even if they agreed, even if the widow says, yes, put me in the venture capital fund that's going to expose me to an enormous amount of risk, you can get your license taken away. So self-regulation of brokers would have worked better for mortgage brokers than what the government regulation was. And you don't have to take my word for it. Justice Douglas, William O. Douglas, far from a right-winger, when he was at the SEC, gave a speech to the Hartford Bond Club in 1940 when he was supporting the Maloney Act, which ensconced self-regulation for brokers, said, government is too blunt. Sometimes you need a tool that gets into the cracks, and that's a place that self-regulation and self-regulation alone can go. And the broker's suitability rules are a perfect example of that. So I, for one, would champion self-regulation of mortgage brokers.
Yeah, I think the fundamental observation here, and I think this debate we're having, after you said your proposal, Chuck, demonstrates that no one size fits all. And what we need is a wide diversity of tools, as wide as possible. And there will be situations where senior people at corporations should go to jail. And there will be situations where groups of peers should adjudge their conduct. And there will be situations where people get a letter, please don't do that again, from an examiner. And things like that. And unfortunately, I think the regulatory regime we've been constructing recently, and I'll come back to this when I talk, is too much of a monoculture. It's too directed to single, isolated tools, instead of saying we need as wide a variety of tools as we can possibly get. But with that caveat, Chuck, I think any kind of thinking like this, like how can we bring a new and different form of social norming to a particular sector, is good. And maybe it works. And if it doesn't, you know what? We move on and try something else.
Well, and I'll just jump in and make one quick point, because I want to be careful we don't ascribe to sort of a false dichotomy here. The government has the power to regulate beyond the power to prosecute fraud or to regulate fraud. I mean, there are plenty of instances where government rules and government regulations set negligence as the standard. And so we really shouldn't be thinking about this as only government regulation, which roots out fraud, and only self-regulation, which goes to ethics. Government regulation actually can span the entire spectrum, even though sometimes Congress just chooses to use fraud or to make the important regulations fraud-based. But there is such a thing as regulating for negligent conduct as well.